thought about that, but I wasn't sure. All right, now we're up and running. Good morning, Council. This is the second session of the Kansas Court of Appeals today on January the 10th, 2022. This is case number Esten Millard versus Kansas Department of Revenue, number 123-390. Today, I have the honor of serving with Judge David Bruns, who has been on our court since 2011, and Judge Sarah Warner, who has been on our court since 2019. My name is Kim Schroeder, and I have been on the court since 2013. Counsel, after you make your appearances, I will ask you to as Mr. Anderson, as the appellant, how much time you want to reserve for rebuttal. With that, counsel, please enter your appearances.
Thank you, Your Honors. May it please the court. Appearing on behalf of the appellant, Mr. Esten Millard, is retained counsel on the Anderson Group in Kansas.
May it please the court, Ted Smith with the Kansas Department of Revenue, appearing as the appellee, state of Kansas respondent.
Thank you. Mr. Anderson, how much time would you like to split?
Just reserve 2 minutes for rebuttal, Your Honor.
All right. With that, counsel, you may proceed with your arguments on this case.
Thank you. May it please the court. The issue in this case really comes down to, though I think both the Mr. Smith and I have argued it in a different manner. I think the issue I raise has an even lower evidentiary standard, so it's kind of all encompassing basically. But the issue is whether or not that we raised was whether or not the officer who was conducting a public safety response to my client when his vehicle was seen by neighbors in his driveway on with the engine being revved up consistently, which was consistent with the gas pedal being, floored basically. Officers responded, saw my client in the vehicle passed out after some quite a bit of attempt to wake Mr. Millard from the officers. He finally woke up, rolled down the window. One of the officers was able to reach in the vehicle, turn the vehicle off by removing the keys, and then my client got out. They then began to speak with him and ultimately turned it into a DUI investigation, arrested my client for driving or operating or attempting to operate the vehicle while under the influence. Arrested him, took him to the sheriff's department, and tried to get him to do, first on site, talked to him about doing field sobriety tests, which he said he was refused or said he would be unable to do. And then I ultimately tried to get him to take the breathalyzer or the intoxilizer machine at the sheriff's department, which he refused. So at that point, based on the refusal, he was suspended. We filed a request for an administrative hearing with the Kansas Department of Revenue, which was heard, and the suspension was upheld. We then timely filed a petition for judicial review to the district court. After some delay, we finally got that before the court, and ultimately, after the court hearing argument, took the matter under advisement and found and upheld the suspension based on the fact that more or less that Mr. Millard was in the vehicle with the vehicle running, and ultimately was the officers believed he was intoxicated, although that no evidence was ever able to be collected, no substantial evidence was ever be collected of that, because due to Mr. Millard's refusal, obviously, but based on the officer's training experience, so there was factors certainly involved that would suggest intoxication. Really, the only issue we raise is that there was no indication that he actually operated or attempted to operate the vehicle.
Mr. Anderson, before you proceed, because I know that's what the heart of this is, but I want to just make sure there's no factual dispute here. It doesn't seem like. I mean, I think we all agree what happened, the state they found him in, that he was He was in the car, driver's side, slumped over the steering wheel. His foot was on an accelerator and revving up the engine. And that's all. And that he refused subsequently if refused. So that there's no fact issue, right?
I would agree.
Okay. So go ahead with your argument then.
Okay. So the as I cite in my written brief, or Mr. Millard cites his written brief on behalf of his argument, and also the Kansas Department of Revenue cites, we all basically cite the same cases because of it's really what this case is about, distinguishing those facts to the facts before the court today more than anything. The biggest factor, the biggest distinguishing factor I try to, reading this brief that I wrote, probably, I don't remember when it was filed, but well over a year ago, looking back, playing Monday morning quarterback, I'm just like, wow, I could have done this different. It's interesting to kind of, after all this time, read back and look at it, especially continuing to do DUI practice and these type of hearings over the last, year and a half, 2 years. It's interesting to look back at some of this stuff and what could have been done differently, but obviously we're here before the court of what was actually done. So I'll try to limit that. But in any event, every one of these cases that I start off citing, and that I really think that if I sat here and did a chart, I think that the Kansas Department of Revenue also cites each one of these cases, starting with State v. Kendall from 2002, where the officer found the defendant slumped over the steering wheel of his truck, wearing a seatbelt, foot on the brake, motor running, at brake lights on. In that case, the truck was in neutral. However, the common theme that I tried to point out is he was in the middle of a public street in a residential neighborhood. The next case we talk about being, I'm going to probably mispronounce this, but Furmeyer versus Kansas Department of Revenue. Again, officer saw a vehicle stopped at a stop sign. He was on a public roadway. Fisher v. Kansas Department of Revenue stated in my brief, or cited in my brief, Fisher was found in the driver's seat at a convenience store parking lot. Kent versus Kansas Department of Revenue, which is an unpublished case. And I apologize, the last case was also unpublished. I did not mention that, but in any event, and Kent versus Kansas Department of Revenue, a deputy found the truck in a parking lot. Again, driver's seat, car running, radio blaring. And then Braun versus Kansas Department of Revenue, which is also unpublished. Braun was found asleep in his vehicle, parked on the shoulder of a rural road, engine running. In all of those cases, the vehicle was somewhere that it could not have been had it been operated by the person who was in the driver's seat. The difference here is my client's vehicle was exactly where it belonged. It belonged in his driveway. Just to suggest that he, even with this low burden of either reasonable suspicion or the burden which Mr. Smith cites, that the law enforcement has to show that they had reason to believe that the defendant was operating the vehicle. Even with that low burden, the problem is that what we're saying is that somebody could never be in their car, in their garage, or in their driveway without saying that we've met that burden, because all these other places all these other cases cited, and I understand that all of them are unpublished, but the purpose of citing those cases was that they're consistent with, that there were KDR cases, and they're consistent with what the exact issue is that all those cases, the vehicle was somewhere where it could not have been had somebody not operated it.
So counsel, if you take that into isolation, I think we would all probably agree that simply going out and starting your car in the wintertime, nothing wrong with that. But we have to consider, and the district court had to consider all the evidence, correct? Not just one piece of evidence in isolation.
I don't disagree, but then
But let me ask, I just want to make sure we agree with these premises. And you agree, we're not talking about a beyond a reasonable doubt standard had he been charged with a DUI. We're talking about a reasonable suspicion standard. Is that accurate?
Absolutely. I mean, we not that it matters to this court at all, but we took this case to trial and he was found not guilty on that standard.
Well, I could see under beyond a reasonable doubt, but that's not what we're here for. And then the other thing I want to make sure that we're all clear on, and tell me if you disagree, is that the district court and this court, to the extent that we can consider the evidence, but the district court in particular at the de novo trial, could consider reasonable inferences from the evidence. Is that accurate?
I agree, yes.
And do you agree that there could be more than one reasonable inference here as to what his intent may have been?
Yeah, absolutely. But I think what my main argument focuses around is the difference, obviously, between the cases that we've cited and the fact that my client's vehicle was in the driveway. But
are you saying that you could never let's say an officer, I know it didn't happen in this case. Let's say they followed me home and I'm sitting in my driveway by the time they catch up with me. I mean, you're not saying that anytime you're in your driveway or in your garage, even, that there could never be a set of circumstances that would rise to the reasonable suspicion of attempting to operate a motor vehicle, are you?
Well, no, of course not. And I mean, obviously, your example is the complete opposite extreme, because
right, that's one extreme. Another extreme would just be I went out to start my car to warm it up because it's cold outside, like it was last week. I probably did that.
Exactly, and that's kind of what, or that's exactly what our argument was all based on. Whether it be I mean, the evidence presented at the trial was different than it was more involved, and then what we have before us here. So I'm trying to remember that and make sure I limit it just to what's before us here, what's before the court here. But so obviously, yeah, of course, there's different inferences that can be made, but
Counsel, I understand you to be making what I kind of interpret as a common sense policy argument that someone shouldn't be arrested or have their license suspended for DUI if the movement is contained to the driveway and not a public roadway. Is that accurate as to what you're arguing?
No, I'm in no way suggesting that there was any movement, whether it be back and forth in his driveway or in and out of his garage. No, I'm not suggesting that there was any movement or any inference.
No, I'm sorry, and maybe I shouldn't have used movement, but if the vehicle is only located in the driveway, it's not on a public roadway, you're using that as a distinguishing factor, right?
Yes, ma'am, absolutely.
And is there, I understand your argument, but could you point me to where in the Kansas statutes that differentiation exists? So I'm looking at 8-1567, and I don't see anything that would distinguish that conduct from conduct that would be such that it could give rise to a license suspension.
Well, there's nothing in the statute that as you're asking me to distinguish, what I'm trying to distinguish is that in order for the suspension to be upheld, the officer has to show that that there was now I forget the actual term, but he has to be able to show that there was an attempt to operation or attempt to operation, and it could be just inferred based on the situation. And I'm looking for the actual term.
So are you saying the inference that he was in the pickup, it was running and he was racing the motor is not operation?
Yeah, I'm absolutely saying that. Yes, Your Honor. Because I can mash on that pedal as long as I want. And unless there's a malfunction, that vehicle's not going anywhere. I have to, in order to attempt to operate the vehicle, I have to try to put it into gear. If I don't try to put it in gear, I have not attempted to operate that vehicle. There's no way that vehicle goes anywhere unless there's a malfunction, and I can stand on that accelerator until it runs out of gas. And
Well,
it's not going
Council,
to.
we could say that you haven't successfully navigated the vehicle, but couldn't we also say that you have in fact attempted to operate the vehicle at that point?
I disagree. There's no way the vehicle operates by stepping on the gas pedal unless you put it in gear. That's a huge distinction between attempting to operate, because I go out completely blitzed. I go out to my car, I turn it on, and I sit there and rev it up, trying to warm it up because I got locked out of my house and I'm freezing, and I couldn't get in my house because my wife locked me out because she thinks I'm an idiot for going out and getting drunk. Then I can get in my truck, I can turn it on and rev it up all day long, trying to get it warm because I'm freezing to death. And I've not once attempted to operate that vehicle. I've attempted to warm myself up so I don't freeze.
But again, in a criminal case, that's a great defense. In this case, you've already said there could be a variety of reasonable inferences that could be made. I mean, certainly what you're saying, that could be one reasonable inference, but couldn't a reasonable inference also be that he's attempting to operate this vehicle, especially when he has his foot on the accelerator? I mean, that's over and above what you have in some of these other cases you've cited.
No, excuse me, I disagree. That being first and foremost, which I've said, and I will, I guess, try to quit beating that horse. But the fact that the vehicle was found somewhere else where it would have had to have been operated to be in that location. But again, in this instance, if we're saying stepping on the accelerator is the same thing as putting it in gear and operating it, that's all the same, then there's no difference than getting in the car with the keys that you've now attempted to operate it. Because
we're looking at the total variety of factors under the evidence and what are the possible reasonable inferences out of that. And I thought you had said earlier when I asked you that there could be a number of different reasonable inferences that you could be reasonable and infer, yeah, he is getting ready to drive. Yeah, he is, has driven, or he's just out there because, as you said, his wife kept him out of the house.
Yeah. So, I mean, I guess if any reasonable inference could be made, and that equates to operation or attempted to operate, then having your car keys in your pocket and being drunk, you could make that reasonable inference that you were going to attempt to operate your vehicle.
Well, I think we probably carry our car keys. If I'm at a Chiefs game and I'm inside the stadium and I have my car keys there, they wouldn't. What we're talking about is all these pieces of evidence, and what I think you're trying to do, and I can't blame you, and you may be right. Who knows? Somebody may say you're right, but we can't just look at any of these one factor. If you take any one factor in isolation, it's probably not enough. You have to look at the totality of the circumstances, all the evidence that's available to a reasonable officer, and then determine, is there a reasonable inference that officer made of a suspicion that he was attempting to operate a motor vehicle?
Yeah, and my two biggest arguments to combat that is that he nobody saw him operate. He was in his own driveway, so there's all sorts of inferences to be made from there. And B, the vehicle will not move just by stepping on the gas pedal. It's impossible. Minus and that's just common sense. I mean, obviously, there's nothing in my brief that cites to any type of authority of that, but I think that any adult that's driven a vehicle understands how that works. That's common sense. But there's no way for the vehicle to be operated unless you try to put it in gear. And we're making inference upon inference in order to come to the conclusion that my client tried to operate that vehicle or attempted to operate that vehicle just because the vehicle was running. Because the vehicle was running and he was stepping on the gas pedal, that means he must have tried to put it in gear and must have tried to move it or must have been the one that drove it there. We're making inference upon inference to get to our conclusion. And I think that any legal standard we're talking about, we can't reach upon stacking inferences.
Counsel, unless the other members of the panel have questions, I've allowed you a little leeway in exceeding your time. So I'll let you wrap up, or you can just reserve for rebuttal.
I think my last statement was my conclusion, Your Honor. Thank you.
Thank you very much. Mr. Smith?
Good morning. Thank you, court justices, for letting me appear and argue in behalf of the Department of Revenue. Your Honors, we would respectfully ask the court the district court decision to affirm agency action and to suspend the licensee's record. When confronted with the issue of a DUI and what is physical control versus operation, obviously there's different lenses you look at it. And in a criminal case, like the courts pointed out, it's beyond a reasonable doubt. And you're looking at it from the perspective of the defendant, and do all facts support a conviction? Beyond a reasonable doubt. Then you're obviously dealing with issues of probable cause or reasonable grounds, which is what you'll see in the Implied Consent Act as far as one of the standards for requesting a breath test. More than a mere, it's probable cause. We all know what that standard is. It's a little bit higher. Does a reasonable officer believe that a crime is being committed? The licensee, the appellant, has chosen to go even further and argue that this is really an issue of articulable suspicion. So whereas when we're dealing with the criminal court and it's looking at the evidence beyond a reasonable doubt to the benefit of a criminal defendant, the licensee appellant has chosen to ask this court to review the district court's decision under an articulable suspicion, where there's a lot more benefits given to the officer as far as how he evaluates evidence. In this case, what we have, I agree that there's really uncontested facts, but those are the facts that were argued to the district court. If you look in volume 1 around page 14 or page 15, you'll see that the licensee presented his legal argument to the district court. And if you read that argument, we're dealing primarily with issues of attempt to operate or operate. Was there sufficient evidence? The licensee has chosen to argue articulable suspicion, which I believe is even a lighter standard for the state to justify this officer's actions. And in this case, what we have is we have two officers that are dispatched to the scene. They don't understand the circumstances, and they don't in most of their cases when they're dispatched, whether it's a criminal investigation, whether it's a safety investigation, they're simply directed to go for a good reason, and they get there. They don't know who owns the vehicle. The two officers that initially arrived, they don't know what the circumstances are. What they arrive is they find someone alone in a vehicle with literally their foot pushing the accelerator down to the floor. Neighbors are calling in, it's so loud. If you look to the DC 27, which is part of the record on appeal, you'll find that there is no alcohol found at the scene in the vehicle, in his presence. So what the officers have is they have an unknown individual. They have to knock on the door for a few minutes to wake him up, and he's barely responsive. One of the officers literally reaches in and turns off the ignition. And during the subsequent encounter, once Mr. Millard is exited or is basically able to leave the vehicle, he is completely impaired. He refuses to answer questions, refuses to do field sobriety tests. So these officers are limited to the facts that they have. Every case is different. And Mr. Millard played a role in how much information was available to them. Now, I believe if you look to the transcript, there's a third officer who arrives who knew who Mr. Millard was. But, that's really the extent of the evidence here. We believe under an articulable suspicion standard, the officer's conduct in initially approaching and also extending the encounter to try to follow up and possibly invest for DUI are legitimate and supported by the evidence.
So I'm curious as to what your thoughts are on your opposing counsel's argument that in each of these instances where we have found that someone who is perhaps non-responsive has been operating or attempting to operate a vehicle, it's been in a location where that person would have had to have traveled to that location. I was wondering if you could respond to that.
I will, Your Honor. Thank you. First of all, I'll say again, as framed by the appellant, we're looking at the articulable suspicion of the officers. And it wasn't immediately apparent to those officers.
Counsel, I want to stop you for just a second. Regardless of how it's framed by appellant or by the appellee, I mean, the law is what it is in terms of the standard that we review, right?
Yes, Your Honor.
Okay.
So I will just point out that, first of all, you go back to Fish and you go back to Darrow, State v. Darrow, criminal cases that are trying to interpret a statute. And they reach a conclusion. You're really looking at a standard between actual physical control versus drive, right? Now, drive is normally equated with moving, but that's not really explicitly set out in Fish or Darrow. They basically say if someone simply has their keys in their pocket and they're sitting in their vehicle, that may be actual physical control, but that's not driving. Now, what this court has to address is how far along that spectrum between actual physical control and moving a vehicle at 80 miles per hour on the interstate does driving, or does DUI, does implied consent laws apply? We would argue, number one, that basically having the accelerator pushed to the floor would consist of effectively trying to drive the vehicle. It's way beyond actual physical control of the vehicle. It's going beyond, it's taking a very significant step, a dangerous step, trying to engage that vehicle or move it. And I know it's not equivalent to, again, driving and moving the vehicle on an interstate at a high speed, but it is further along the spectrum towards that than it is simply someone sitting in their vehicle with their keys in their pocket. That addresses the issue of operation. The second issue here is that we're dealing with a refusal. And the legislature, after these cases like Fish, Darrow, Kent, they basically created this attempt to operate. Actually, Darrow's afterwards because it's evaluating this. But in Darrow, what you have is a lady who is behind the wheel of a vehicle trying to engage the gears, but the vehicle never moved. And the court found, hey, that's sufficient for attempt to operate. We would argue that what you see here, what these officers saw here under their articulable suspicion standard, was a similar overt act. Someone pushing the vehicle accelerator all the way down to the floor. Now, is that in the state of mind of the licensee? We don't know, but that's not really the standard for this officer and for this court's review. We believe that what you observe, the facts available to you, support an attempt to operate and therefore support this encounter, this eventual arrest, and this request for a breath test. It's a real long-winded answer to your question. I hope I have addressed it.
Anything further?
No, Your Honor, we would simply ask the courts, the justices, to evaluate the cases and to find that the officers' conduct and decision-making based on the evidence, information available to them at the scene was supported, that an arrest was lawful, and that agency action be affirmed to suspend the license for refusal of a breath test.
Thank you, counsel. Mr. Anderson?
I don't think there's any more reason to belabor the point. I think that as the court, we started off agreeing that the facts in question were agreed upon by pretty much, we quoted all the same facts. I don't think there's any big argument with that. And all it comes down to is really what this court interprets this court's prior rulings, the Supreme Court prior rulings on what attempt to operate is. I think that basically it comes down to Mr. Smith's argument is that pressing the gas pedal is attempting to operate as an overt act. And as I previously stated, we don't believe that that's the case. As a matter of fact, the case he brought up, State v. Darrow, the Supreme Court of Kansas found that when the officer tapped on the window and she kind of came to and grabbed the gear shift, that was enough to could be considered an overt act to attempt to operate the vehicle. Once again, Mr. Millard could have stood on that gas pedal until the truck ran out of gas, and that vehicle was not in operation or able to operate just because he was stepping on the gas pedal. So that's the big distinction we make, and that's where I win. Thank you, y'all. Thank you, court.
Any further questions by panel?
Nope.
Well, thank you, counsel. It's an interesting issue. It's been well argued. We'll take the matter under advisement and issue opinion as quickly as time allows.